Now to another of our top stories, and the tug of war between the Independent Electoral and Boundaries Commission and Parliament over the publication of spending limits for campaigns has hit another wall. The High Court today upheld Parliament's decision to annul campaign financing regulations, arguing that the IEBC had not adduced evidence of adequate public participation. Gina Kirori has more on the intrigue surrounding the law, which is meant to regulate campaign spending.
To say that the Election Campaigning Finance Amendment Bill has been a slippery slope would be putting it mildly. If passed, one of the proposed sections would require that candidates, political parties and referendum committees keep all records of all income and expenditure relating to electoral campaigns, audit their accounts and make returns to the Commission, and that the Commission may conduct an independent audit of the accounts of a candidate, a political party or a referendum committee if it deems it necessary. The country will once again be heading to the polls without the regulations meant to cap campaign spending. This is after High Court Judge Anthony Mrima absolved Parliament of wrongdoing.
This case is all about compelling Parliament to do their job. They've not done their job.
Parliament had argued that IEBC could not publish the spending limits as they had not carried out adequate public participation.
Had they furnished the court with evidence of public participation, then now the National Assembly would have been faulted for not having passed the regulations.
But I'm sure politicians will feel nice that, yeah, we've gotten the protection. The protection they've gotten is not because they did the right thing. It's because IEBC failed to show that there was evidence of public participation.
With IEBC failing to produce evidence that public participation was carried out, it has now thrown a wrench in the already slow process of compelling those seeking elective positions to disclose their sources of income for purposes of their campaigns. A process that has stalled since 2016, with the next possible time it can apply being in 2027.
The court was very categorical that that is the exclusive mandate of the IEBC and not the mandate of the National Assembly.
The push and pull between IEBC and the National Assembly has been evident, with the National Assembly being reluctant to pass regulations as they argue some of the sections are unconstitutional. But human rights groups say they intend to pursue the matter further.
IEBC will revise the regulations. It publishes them in the Kenyan Gazette, and that way, that will give IEBC a chance for public participation. Then once it has published the same, now that will be forwarded now to the National Assembly for approval.
It's important because unregulated use of money, other than creating a terrible compulsion for corruption, i.e. bribery and voter treatment, it can also provide an opportunity to insert or pollute the political process with illegal money.
Meanwhile, the High Court also dismissed a petition by former nominated Senator Paul Njoroge, which sought to postpone the August 9th presidential election. Njoroge had argued that conducting the election on the said date would have reduced the 5-year term of President Uhuru Kenyatta and his deputy William Ruto, as the pair were elected on November 28, 2017. Gina Kirori, NTV.